Today's presentation will be recorded, and we will post the recording sometime at the end of the day today if you want to go back and watch that or send it around. So the objectives of today's presentation are to review Washington's legal requirements for withholding or withdrawing life-sustaining treatment, and also to recognize when a guardianship appointment or court authorization is necessary for withholding or withdrawing life-sustaining treatment. Quick disclosure, none of the speakers and none of the planners today have any relevant or financial relationships and nothing else to disclose. If you are a UW learner and want to text for your attendance, you can text this number on the screen. And if you already have an account with the CME, all you have to do is text the code 11126. If not, you will just send your UW email for the initial message, and then you should receive a confirmation if everything is going correctly. And then I will go ahead and put that code in the chat as well if you need that later. If you're not a UW learner and you want to claim continuing education credits, I will send a survey out and your attendance will be recorded, and we will submit for all of the CMEs at the end of our series in June. So further instructions will be sent out to anyone who's looking to claim credits. A quick announcement about our summer seminar in healthcare ethics. This is an annual conference. Registration is now open. So if you're interested in attending any and all of this conference, we do have a slight increase in price for it's now for 3.5 days instead of just 3. It is completely virtual, and we are having a special early bird discount for 20% off the full registration cost. We have more information on our website for possible group discounts, or if you're in financial need, we have a scholarship process for people that can't otherwise attend. Some future forums. We have a great one next month with Dr. Lori Bruce about community bioethics. More information on that will be coming out later. And we're also having a symposium at the Department of Bioethics and Humanities in conjunction with this international symposium. More information is on our website. If anyone has any questions about that, feel free to send me a message directly in the chat. So a quick introduction from our speakers. We actually do not have Dionne Williams today, but we have a wonderful stand-in, Bianca Caballero. Am I saying that right? Caballero?
Caballero, yeah.
Oh, okay, great. Jill, did you want to start on the intros?
Sure. Carrie, will you look for the slide that discusses the case? It's in the slides I just sent you, but I'm just really grateful to have this panel convene today to discuss the legal considerations of patients who are critically ill and dying, and involving patients who lack surrogate decision makers. This is a common case that we've seen at Harborview in the Ethics Consult Service, and I know a common case that you've all dealt with on the wards as well, or in the ICU setting. We are really grateful to convene this panel. Bianca, I know less about you and have less to say, but I know that you're the Director of Social Work in the Ambulatory Bed Readiness and Complex State Pilot at Harborview. We also have with us today John Gibson, who's the Assistant Director of Clinical Risk Management for UW Medicine. In addition, we're fortunate to have two of the lawyers that we work with from Brothers Henderson and Durkin, and Amy Spitzer's with us today. She's an attorney there and has her practice is dedicated to helping hospital systems with issues related to guardianship, surrogate decision making, patient capacity, and difficult placement issues. Mackenzie Weiberg is a lawyer also from Brothers Henderson and Durkin, and she's been working on elder care and representation of hospitals in the initiation of adult guardianship and conservatorships for their patients. She works with Washington State Department of Social Health Services, the Home and Community Services, the Office of Public Guardianship, and various other professional guardians. She's been in practice since 2021. And we'd also like to welcome Michelle Nelson. one of our assistant attorney generals who works with the University of Washington in the state attorney general's office. She has provided legal support to UW Medicine with emphasis on Harborview. And prior to coming to University of Washington Medicine, she worked at Washington State Hospital and has represented the Healthcare Authority, including Medicare programs and insurance programs, PEBV and a CPB. She holds a JD and an LLM from Georgetown University Law Center and has worked on behalf of the U.S. Federal Trade Commission Bureau of Competition, Georgetown Center for Health Insurance Reforms, the O'Neill Institute of National Global Health, and Whitman Walker Health, and the National Center on Protection Orders and Full Faith and Credit. This discussion today will focus on a case. Keep the case, Carrie. No. I'll just tell you the case. The case we want to address today is related to the Harborview patient who's critically ill, who lacks decision-making capacity, and after an exhaustive search from the social worker, we haven't been able to find a surrogate decision maker. In this case, there's consensus among care team members that medical treatments are no longer thought to be beneficial, and our patient is thought to be terminally ill. The social worker petitions a court to appoint a guardian, but the team worries that a timely appointment is rare, and many guardians are, and they also worry that many guardians are uncomfortable consenting to terminal withdrawals. But meanwhile, burdensome treatments continue, and the care team decides not to escalate treatment, but they are aware that they cannot unilaterally withdraw life-sustaining treatments based on Washington State case law. A DNR is signed by the attending physician for this patient based on medical futility. That will be the focus of our conversation today, and we're going to start with Bianca to help us discuss the social work role in helping move this case forward.
Hey, again, my name is Bianca Capolero. I'm from social work and care management, and I'm a director of social work here and have worked on the inpatient side for almost 20 years. So having and now do more work on the ambulatory side. So having that experience, I think this is a case we often see. I will talk a little bit about guardianships in general, and then specifically about this situation. But I think in general, we usually will proceed with going for guardianship when a patient lacks capacity, right? And there's non-emergent procedures that need to be done, and there's no legal next of kin or surrogate in place. When a patient needs something urgent or emergent, then we go a different route. But for those non-emergent situations, like withdrawal of care, that's not an emergency, right? Or a PEG placement, that's not an emergency. Then we usually have to proceed with guardianship. The other reasons is a patient lacks capacity and we have discharge needs that need to be addressed, or we have funding issues that need to be addressed. And I think one thing to remember generally is, in general, a guardian cannot force a patient to do something, right, that they don't want to do. If a patient refuses placement or refuses something that the guardian wants, we still can't make that happen. And all less restrictive options should be explored first. And we also get into the situation where there's a moral distress about a situation, and that doesn't, and seeking guardianship does not necessarily answer those situations either, and give us an appropriate outcome. we are generally looking at like, what do we want to achieve with this guardianship? And so if that's something that can be achieved through the legal process of guardianship, we should proceed. But if that's something that the outcome is just, we want this patient to do this, that's not necessarily something that we should always proceed with guardianship for. And so that's a question we're always kind of thinking about as well when we do go forth with guardianship. Move forward. Okay. So what are the different types of guardianships? There's what most people consider guardianship. What we do a lot here in the hospital is guardianship of person, making those decisions, having somebody go through the courts to make decisions for somebody. Conservatorship, and that's guardianship of a state. And we often have that happen because we need access to their finances in order to move funding forward. And then this is emergency guardianship, and this is kind of what speaks to this situation. If we are in an emergent situation, we can ask sometimes for an emergency guardian that only lasts 60 days. It can be extended, but this is a very high bar that we go to the courts for approval for. And this is when we do this, we usually need to have somebody who's willing to be guardian. And if we don't have somebody who's willing to be guardian, then we would potentially go through the process still of seeking guardianship and looking to see if that court visitor can, who's assigned by the courts, be that person to get a court order for us to move something forward. And our attorneys can talk more about that, but that may not always be the outcome even that we want, even if we go through that process. So it's not a straightforward process. It has happened before, we've done it, but it's not always straightforward, and it's not always, we don't necessarily get the outcomes we want every single time we go forward with this process. And who decides if a patient is appropriate for guardianship and initiates that process? The assessment is
I'm trying to get this to
the decision that to move forward with guardianship is always going to be the primary team. Can you guys hear me still? The primary team. Okay, perfect. The primary team is going to make that final decision. Often we get consults from psych if that's what's appropriate, but really it's the primary team who's going to complete the physician form that's going to move the guardianship forward. And then there's a section that the social worker has to complete as well that we provide to the hospital, and then our administrators, and then the attorneys that then take that information to move it into the court system. And why does it take so long? That's probably the question we have most often. The process, especially within King County, and now there has been a change in law about if a person is from Yakima, we have to file in Yakima, right? So even though we are based here in Seattle, that puts another burden upon our attorney. So if in this situation we wanted to withdraw care from somebody, and it was medically appropriate, and we think that's the next appropriate step, we actually would have to file in another county. And so and every county is different, and the process should be the same, but the timelines and such are all different. And the commissioners there might have different opinions, right? And so, and again, that's where we don't know if the outcome that we are seeking is going to be what we thought we were going to when we first filed. And again, not in this situation, but to always think about if a guardianship is marginal or the concerns about the patient would disagree, that a guardianship can go to trial if a patient disagrees with it. And that can create significant delays in the process and increase the cost to the hospital as well. And so as a side note, when we're thinking about these situations, because we've had patients who we thought were appropriate to withdraw care from that, there were a number of different factors, but anything that complicates a situation usually means a longer process. And so just to keep that in mind with whatever situation that we're in. And in these cases, even in the withdrawal of care, we don't always have to wait for a guardian to be appointed. Our attorneys can seek court orders through the court system to get to allow that whatever the judge has signed off on to move forward with that, such as withdrawal, such as placement, such as funding. So we can go through those processes. And so we don't always have to have a guardian in place, but it depends again on the question and what we're trying to achieve, if it's appropriate for the court visitor to make that decision, or we need to wait for the guardian. And every once in a while, we have this happen where a guardian or even the court visitor doesn't agree or is non-responsive. Like in these situations, our attorneys at Brothers and Henderson and Fox Ballard really try to seek an appropriate court visitor who can help us and guardian who can help us with whatever situation we're in. Because not all CVs have to do what is being asked of them. And so, and again, they can talk to the legalities of that, but we all do our best to vet that person to make sure that they're going to move forward with whatever we're asking of them. And there are other programs in the community that help with guardianship. The HCS does, the Office of Public Guardianship. And so sometimes we go to them to help us. But in situations where we need something urgent or emergent, we definitely use our attorneys and go through that process to try to move things along quicker. And that's what I have. I don't know if people have questions or we'd have questions at the end.
We'll have questions at the end.
Okay.
Thanks so much, Bianca. And I just want to say thank you all for having us here. Again, my name is Mackenzie Lieberg, and Amy Spitzer is also an attorney in Brothers Henderson and Durkin. And like our intro said, we help represent the hospital in the filing of these guardianships. And so, yes, we're very much aware of just kind of the complicated nature of the case study that we're facing. So just a quick overview. I know we have limited time and we just want to leave plenty of time for questions at the end. But we wanted to go over kind of a few updates for the statutory terms under the new-ish Uniform Guardianship Act. We'll talk more detail about emergency versus regular guardianships, when we would file that emergency guardianship matter, and then lastly we'll go more into the specifics of the case study and specific steps that our office takes. So first things first, Bianca did a great job of talking about what is guardianship and conservatorship, but just a little bit of overall background. The Uniform Guardianship Act is a newer-ish statute that was implemented in January of 2022. It kind of reworked the guardianship laws in Washington State, and so we've now had a couple of years of practicing under it. So we have a good understanding of both how it operates, kind of some of the pitfalls, as well as some creative workarounds as to how we can get things done for the patients. Some of the key term differences are, like Bianca said, conservatorships, which is the same as guardian of the estate. It's essentially the management of an individual's finances. The Uniform Guardianship Act also reworked a bit what was commonly known as the guardian ad litem into being what's now known as the court visitor, still serving the same purpose and role of being appointed on a case, investigating whether an individual actually needs a guardian and conservator, and then writing a report, excuse me, and recommendation to the court. I think in the prior statute, that guardian ad litem had that immediate authority to help with any emergent medical services that were needed without us having to actually go in front of the commissioner and seek kind of any interim authority. With the new UGA, there we have to add that extra step, unfortunately. And kind of the two biggest changes to the new law is that the UGA implemented a time constraint for filing without a nominee. So previously, under the old statute, we could file without a nominee and just file immediately, look for a professional or look for family members, while also having a court visitor or guardian ad litem also be on board assisting. With the new statute, we have 30 days. So that's why we'll often say, you know, we can't just file right away because it depends on how long it takes to find a nominee, unfortunately. At that 30 days, the court can dismiss a guardianship conservator petition, and we would have to kind of start the whole process over again. And the last key difference is the introduction of emergency guardianship. So I'll talk about that more in the next slide. In the instances of the critically ill or dying patients, we could very easily make the case why an emergency guardian should be appointed right away. With that emergency subsection of the statute, we could have somebody appointed within a day of filing. In the ideal world, we would have, you know, everything lined up. We would have medical declarations from providers, from social workers in support of our petition. We would have the nominee all set to go and ready to consent. We've recently filed a petition where a patient needed a PEG and trach. And so we were able to get that all together and going, and the person was able to have that recommended procedure right away. And like Bianca said, the standard is really high. You know, it's kind of county specific, commissioner specific, which makes it all that more interesting. In King County, you know, they don't see discharge purposes as being emergent, versus Snohomish County, they recognize it. So it's kind of a roll of dice depending on where that patient is from and where we file. The biggest speed bump for emergency guardianship, though, is the need to have an individual who is willing to be appointed prior to filing. So in our case study, it's unfortunate that, you know, the key speed bump is that they lack a surrogate decision maker. So we can't file that emergency guardianship, although it would constitute an emergency, because we don't have somebody on board right away. I think on paper, everyone was super excited about the emergency guardianship, that, you know, we would have this mechanism to be able to help these folks in a super timely manner. But in practice, it's not used as much, unfortunately. On the flip side, if there is someone who is willing to be a guardian, that person likely qualifies as a surrogate decision maker under a separate statute. So we always recommend, you know, that route if there is somebody involved, just because getting the court involved, unfortunately, slows things down. But with that said, we've kind of found the creative workarounds of seeking interim authority. And so I'll talk about that in our next slide. So like Jill had read, we've got our case study of a Harborview patient who's critically ill or terminally ill and lacks a decision-making capacity, as well as a known surrogate decision maker. The consensus is that members of the care team believe that medical treatments are no longer thought to be beneficial. So in the next slide, I'll talk about what our office does, kind of the steps that we take and how we would serve this kind of patient. So first things first, we know that the case managers and social workers do an amazing job of the heavy lifting of looking for anyone and everyone that could be related to this person, family members, friends, et cetera. And just like they do, we also want to do our due diligence of looking for somebody through background searches. And we've in the past had a few random successes of connecting with a sister on an email from a Lexis background search. So, we just want to make sure that we cover all our bases as well. Concurrently, we're recruiting for a professional guardian. And like Bianca said, the question of how long does that take gets the annoying lawyer response of it depends. It involves us applying to the few state programs available for certain acute care and low-income patients who qualify, reaching out to known professional guardians in the kind of community, and just kind of putting our feelers out there. But the reality is a number of factors make it difficult finding a professional guardian for these critically ill or dying patients. I would say number one being that professional guardians are generally compensated from the income and assets of patients. So if a patient has minimal assets, it can be difficult to find somebody because they would be essentially taking this on pro bono, and there's only so many kind of pro bono cases that professional guardians can take on to sustain their own business practice. Another thing is that there's just not enough professional guardians for all the people out there who would need somebody. Unfortunately, even if there's family members that we know of, it takes a lot it's a lot of work being a person's guardian. So getting them on board can be difficult. And lastly, there is that moral dilemma of making end-of-life decisions for individuals that they're not familiar with. What we're also doing is we're reaching out to court visitors. Like Bianca said, the filing for a guardianship has a lot of steps and a lot of roles and people involved. And so it's kind of the luck of the draw when it comes to getting appointed a court visitor and how proficient they'll be. So what we like to do is when we have these cases where there's somebody who's critically ill, we like to get our CVs involved who would be willing outright to accept that interim authority to consent on behalf to whatever medical recommendations are made. And this has likely been our biggest success in moving a patient's care along when they do lack that surrogate decision maker. The legal guardian conservator world is kind of small, so we work with the same folks often. And so we've had a chance to really find those court visitors who we know are both efficient, compassionate, and willing to help. And who will work with the hospital, work with us, work with the patient. So when we find a CV who's on board, we can file that even without the nominee, even with that timing constraint, just because we know that these patients need help. With that and said, we'll concurrently file petition for that interim authority upon the appointment of a CV. And depending on the county is when we get the appointment of the court visitor. In King County, it could take a week. Unfortunately, in Snohomish, we can walk right into the courtroom. So again, it's kind of up to where the patient is from. And if all parties are in agreement, we can also present an order ex parte, which means that we don't have to set a hearing, and we can just submit right away that order to get authority to the court visitor. If it's not agreed, or if there's any objections by a party, or if it's a terminal withdrawal of care, that's definitely a higher standard, and we're going to need to set a hearing to ask for that interim authority and get it in front of a commissioner to kind of make the final call. And look, there's these commissioners are definitely overworked. They have a large caseload, but there are emergency set calendars that we would be able to get slotted on. And in all these instances, regardless of what kind of interim authority we're seeking, like I'd mentioned, we would want a declaration by a provider and possibly even testimony, especially in end-of-life terminal withdrawal of care situations, because I know Amy could probably speak to this better, but in the past, a hearing has been saved by the presence of a social worker or a doctor. And just last thing, that constant question of timing. How long does it take to get a nominee? How long does it take to get interim authority? And it depends, but overall, guardianships take about 60-ish days. Emergencies, ideally, we can get it appointed in a day, but with every case, there's all those fun, complicated factors that weigh into things. So I think I'll pass it on to Amy, who will add on to anything additional she may add, but I know we want to leave plenty of questions at the end, so thank you.
Thanks, Mac. I think you did a great job. I don't have anything to add, and we'll just reserve time for the end for everybody to ask questions.
Before we move on to Michelle Nelson, we are going to hear from John Gibson.
Me. Hi, everybody. I don't have slides. If I did, they would be two of our policies and our entire informed consent manual. The two policies that we rely on regularly are APOP 80.1, which is the decision to withhold or withdraw life-sustaining treatment. The second one is APOP 80.2, which is the do not resuscitate orders for medical futility. When we get these calls regularly from our friends in social work or care management or ethics, we will refer to these policies pretty much every time to make sure that we are taking the right steps. They're pretty well written and thoughtfully written, and I highly recommend that you familiarize yourself with them. And then the informed consent manual is really helpful as well. The reason that I would rely on those is because my department would be involved with the consent type issues. We probably have the least active involvement out of everyone who's speaking today, but the consent issues that we tend to address most often, I think, are the result of some confusion. I think maybe the most common one is someone who is really desperate to try to do the right thing, and they don't want the long process of guardianship. And so they want to make the decision or have the care team make the decision for the patient because it's beneficial to them. And I hear the phrase to physician consent. And there's no such thing in the state of Washington. I think that this can become confusing because there are jurisdictions where two physicians can consent for a patient, but not in Washington. The patient themselves or their healthcare surrogate are only authorized to make the consent decisions. And in fact, the law specifically states that employees of the healthcare facility where treatment is being rendered, and really any healthcare treaters at all, are really not allowed to provide consent. I think where some of the confusion also arises is we do have a form at Harborview, and it's the emergency treatment form. And in that case, two physicians can agree that a medical emergency exists such that consent would be implied under the law. So rather than two physicians agreeing that, well, this patient really needs a PEG tube, we can go ahead and do it. What they're agreeing to is if we don't treat or provide a specific treatment to this patient, they're going to die, or they're going to suffer an unacceptable disability such that we need to intervene. And of course, this emergency exception assumes that the patient is unable to speak for themselves, and there's no surrogate, and there's no DNR. If there's a DNR, then the emergency procedures that we have would be suspended. The other issue or the other confusion that I sometimes hear is the difference between assent and consent. And they are very different. Assent would be providing some sort of non-invasive care to a patient and they don't object, right? But consent is needed for invasive procedures. And so the only place that I am aware of where assent is part of our informed consent process, and I know that this is confusing, but if you look at the policy that addresses the decision to withdraw or withhold care, if the care team decides that further care is futile and a surrogate decision maker does not object, then we can begin the procedures for withdrawing that care. And in that case, it's not really obtaining consent when care is futile, but the surrogates they're assenting to what the care team believes is most appropriate. I think in light of all of this confusion, I would really encourage whenever these situations arise that you reach out to our department so that we can walk through the possibilities, and then occasionally I'll need to go running to Michelle or Amy or somebody to get further clarification on what our options are. But I think I think I'm going to pass it to Michelle now, and if anyone has any questions, we can ask them at the end, or you can feel free to reach out to me after this is over.
Hey, thanks, John. I'm Michelle Nelson. I'm an Assistant Attorney General with the AG's office, and I provide legal support to Harborview. And so today I'll be talking about the Hamlin case as it's still controlling law in Washington and sets out the procedures and circumstances such as our case study today, where you have a patient without surrogate decision maker who is either terminally ill or permanently unconscious and might be in need of withdrawal of life-sustaining treatment. So mandatory disclosure on behalf of my office is that this presentation represents my perspective, but is not a substitute for legal advice. So if you would like to seek formal legal advice from my office, please work through appropriate channels such as risk management, social work, chief medical director, chief medical officer's office to reach out to my team for legal advice. Sorry. So quick note regarding Washington's Natural Death Act. It's, of course, what authorizes advance directives to withhold or withdraw life-sustaining treatment. Of course, when a patient signs an advance directive, they have to be competent, and advance directives are then only applicable in situations where subsequently the patient then is incompetent to make healthcare decisions and is either permanently unconscious or terminally ill. That said, the legislation does contain a helpful definition of life-sustaining treatment to help ground our conversation. It also contains definitions for permanently unconscious or terminally ill, but of note, those definitions aren't necessarily controlling to a court. For example, the Death with Dignity Act has a different definition for terminal condition that has a specific time frame. They have to be projected to be deceased within 6 months, whereas Washington's case law and the Natural Death Act don't have that sort of time frame attached to it. And so quick note as to competent patients. Of course, a competent adult can decline life-sustaining treatment, including artificially administered nutrition or hydration. They can also sign an advance directive should they subsequently become incompetent to make medical decisions. And so there are 3 major cases in Washington that speak to a surrogate's ability to consent to the withholding or the withdrawing of life-sustaining treatment. All of the cases, interestingly, are from the 80s. So the first is Collier, which involved a patient who was permanently unconscious. She had a spouse who was also her guardian, and she had had the ability throughout life to express her wishes concerning end-of-life care. Then there's the Hamlin case, which is most analogous to the scenario, the case study presented today, where the patient was permanently unconscious, did not have a surrogate decision maker, and then also, due to developmental disabilities, did not have the ability to express his wishes during his lifetime as to end-of-life care. And then there's the Grant case, which extended the reasoning in Collier and Hamlin to cases involving patients who are terminally ill. And so brief note on the Collier case, because this was the first case of its kind in Washington that held that a patient had the right to decline life-sustaining treatment that could be exercised through a surrogate decision maker. And in this case, the surrogate decision maker for the patient was both spouse and guardian. And then the court also developed some procedural safeguards that were later modified in Hamlin. But the court articulated that a guardianship appointment was necessary and that the patient's diagnosis of being permanently unconscious had to be confirmed by what it called a disinterested prognosis committee, which was essentially 2 physicians who are not a part of the patient's treatment team. And so the Hamlin case came soon after the Collier case and had one repeat issue, which was whether or not a guardian could legally consent to withdraw of life-sustaining treatment. And the guardianship in Hamlin was a little bit different than the guardianship in Collier. In Collier, that was an immediate family member. In Hamlin, it was actually a guardianship firm, so it wasn't, an individual guardian. The other question that arose was a guardianship appointment necessary to withhold or withdraw life-sustaining treatment? The language in Collier strongly implied to folks that a guardianship appointment was always necessary, even in cases where other surrogate decision makers were available. So not surprisingly, Hamlin was a Harborview case. Patient was admitted to Harborview. He had not expressed his wishes concerning end-of-life care due to his lifelong history of developmental disabilities. He was originally admitted with pneumonia. Harborview filed for a guardianship appointment. A guardian was appointed, and then unfortunately, Mr. Hamlin's condition declined. He experienced cardiopulmonary arrest. He was resuscitated, and then thereafter had minimal brainstem activity. So he did not meet Washington's standard for death, which in a case like this would be total cessation of brain activity. So the treating physicians asked guardian to consent to withdrawal of life-sustaining treatment. The guardianship firm didn't believe that it had the authority to make that commitment. So Harborview petitioned the court to authorize the withdrawal of life-sustaining treatment. So the court did enter an order authorizing withdrawal of life-sustaining treatment, but it essentially paused its order. So the order didn't become effective to permit the guardianship firm to appeal. Unfortunately, Mr. Hamlin passed away before the issue was decided on appeal. But nonetheless, the Washington State Supreme Court decided to take a look at the case so that it could clarify the issues presented. So the ultimate holding of Hamlin was that if no surrogate is available, a guardian must be appointed to represent the patient's interest. The court also refined the procedural guidelines that it had set out in Collier and stated that if the treating physicians, the prognosis committee, so 2 disinterested physicians and the guardian all agreed that removal of life-sustaining treatment is appropriate, then court approval is not required. If there were to be disagreement among those parties, then folks would need to seek approval of the court for withdrawal of life-sustaining treatment. And if a surrogate, so then the court took the opportunity in Hamlin to clarify that if a surrogate is available, in that case, a formal guardianship is not required. And again, same procedural guardrails of if treating physicians, prognosis committee, and surrogate all agree that withdrawal of care is appropriate, then that can be done without court involvement. And just brief note on the Grant case, just because this was the case that extended the reasoning in Collier and Hamlin to patients who are terminally ill. And so the court also required that, not only should the patient be terminally ill, but they should also experience severe and permanent mental and physical deterioration. And in the Grant case, the court also clarified that there's no legal distinction between withdrawing and withholding life-sustaining treatment. The same procedures would apply. And so takeaway in a Hamlin scenario, which is closest to our case study, if a patient does not have capacity to make medical decisions for themselves, is terminally ill or permanently unconscious, and a surrogate decision maker is not available to withhold or withdraw life-sustaining treatment, a guardian has to be appointed to represent the patient's interests. Now, of course, as other folks have spoken to today, the guardianship process needs to be started, but once the guardianship process is started, you can ask the court directly to authorize withdrawal of life-sustaining treatment, even if it hasn't actually gotten to a formal appointment of a guardian. So in practice, it's a little different than the language of the case. And then there's the Collier scenarios, where if it's the same presentation, but a surrogate decision maker is available, then surrogate decision maker can exercise the patient's right to decline life-sustaining treatment, and court approval or formal appointment of a guardian is not required. And then just brief note on cases where the patient is not terminally ill or permanently unconscious. Those cases present a different risk profile because they're outside of what Washington case law has addressed. And so in those cases, if there's a patient not terminally ill, not permanently unconscious, unable to make healthcare decisions, doesn't have an advance directive or DPOA, court approval should always be sought to withdraw or withhold life-sustaining treatment, even if that patient also has a surrogate decision maker available. And thank you so much for your time, and looking forward to everyone's questions.
Thank you so much, Michelle. If anyone has any questions, feel free to type them into the chat, or you could do the raise hand function and go ahead and unmute when you have your question. We do have one question in the chat. It says, please further clarify the prognosis committee.
Yeah, it's a funny term that the court uses, and it's essentially two physicians who aren't a part of the patient's treatment team, so they could be at the same facility. So they could be two Harborview physicians who agree with the patient's diagnosis and would agree that the patient is either permanently unconscious or terminally ill.
And the next one says, if a patient has an advanced care directive for withholding withdrawing care and becomes incapacitated or permanently unconscious, is surrogate decision maker authorized to make decisions counter to the advanced directive, or is the hospital able to honor the directive?
The directive should be honored.
Yeah, I agree with Michelle.
And of course, you are welcome to ask questions to any of our panelists.
Barry, we had some at the beginning that maybe it would be worth going back to. So there are a couple of comments about situations where patients disagree with the recommendation, maybe that both the treating team and the guardianship agree to, so such as placement, such as particular interventions. And I think there are some distinctions between that might be helpful in terms of patients who don't have decision-making capacity. It's not about honoring autonomy if we don't have any understanding of their preferences, but there are all sorts of ways in which we might adjudicate best interests of the patient here. And so I think there are some different situations, but it'd be great to hear from the panel more about how you think about, placement versus something like an intervention that we would be compelling over objections for a patient who doesn't have decision-making capacity and we don't know their preferences.
I don't know if you have a specific question. I can talk a little bit about, the standards for surrogate decision making, or I'm sorry, I'm not sure what the specific question is. If there was one earlier, then I can try to find it.
Maybe Cliff, you have your hand raised, and I think you were asking one of the comments on those questions.
Thanks, Dionne. Thanks for everybody for the time on this. This is great. I was going to ask separate questions, but I can go back to that one too. I had two other questions. One, if somebody could talk more on kind of interim authority and constraints on that, because as in the ICU, what happens sometimes is while you're waiting for guardianship, we have cases right now that are going to take 2 months or more, and outside of emergent consent or emergent implied consent, cases come up like you mentioned, trach, peg, etc. And how often or how easy is it for us to be petitioning for those decisions for all the clinical decisions that we want to make to advance care, but we don't feel necessarily falls under the emergent criteria. But there are a lot of other decisions that we make on a daily basis, and should we, how easy is it to do those? And then the second question is your thoughts on patients who are not critically ill with chronically diminished capacity or marginalized capacity. What happens, I see in those folks a lot, is the practicalities of the guardianship system really fail them, and it often comes to the ethics committee, and we kind of deliberate on that. Specific examples are folks who come in and they have a preference, but they definitely do not have capacity. We get barriers on filing for guardianship, either because they're going to be discharged, and then in the outpatient world, apparently it becomes difficult / impossible to continue the process. Or they're not staying in the hospital long enough for the guardianship process to continue. And so, the outpatient primary care docs tried the process and it fails. We try inpatient, and then they may stay 4 weeks and then they'll leave. And so everyone kind of gets conditioned to just not try anymore. And then what that results in is then essentially you have healthcare providers who are making the clinical decisions for them, which we want to avoid too. But then there's no intermediate into, how we get a decision maker for them. They definitely don't have capacity, but they have preferences. And I feel like we don't know what to do with those cases, and they end up in the ethics committee, and we kind of just, similarly, the ethics committee is also just a group of people that are making decisions for somebody else that we may not want to do that either. So those two questions, and then back to what Gina was referring to. I think the question was on, it was mentioned that just because someone has a guardian, they may not need to be, we may not be able to do something to somebody clinically if they are refusing. And I think the question was more curious on, well, if they don't have capacity. I feel like if a surrogate decision maker is available and they were authorizing care for a delirious patient, we may sometimes listen to that surrogate decision maker if the person is sick enough, and we do that in the ICU all the time. And so there are situations also, and I was kind of adding on to the initial comment, that especially if an intervention is relatively low risk or harm to a patient but provides great clinical benefit, like you can save their life with antibiotics and they just need you to put in an IV or something, I feel like there are frequent situations in which we would follow a surrogate's decision to do that in a delirious patient. And is that different in a guardianship situation for some reason?
Okay, I'll try to remember all your questions, and other people feel free to chime in. But regarding the interim authority, I think as soon as we file a petition for guardianship, the court does have jurisdiction over that patient, even if a guardianship isn't established yet. And so we then have a doorway to the court to make decisions for the patient. So that is something that is readily available. As far as the practicalities go, it's different. Mac described in her presentation that for interim authority, we first have to get a court visitor appointed. In King County, that can take a week or longer. In different counties, it can be the same day or the next day. We also rely on the court visitor to be willing to make those interim decisions, or at least join a petition before the court to get a court order. Some court visitors, even if the court does direct them or authorize them to make decisions on behalf of a patient, will refuse to exercise that authority, and that's within their rights to do so. So a lot of factors have to come into play. So I think it's situational. I think it's hard to develop a kind of black and white policy as to what procedure you should go to the guardianship, what procedure you should rely on other kinds of decision making for. But it is something that is available. It does require, us to at least have a medical declaration from a provider of some sort describing the procedure. And sometimes, depending on the procedure, it will require testimony, usually via Zoom or telephone at the court hearing. Your second question was, I think, regarding the lack of continuity of the guardianship process for patients who are kind of, maybe I'm misinterpreting, but in and out of maybe the hospital inpatient setting. I think as far as the cases that get referred to us, when we determine that a guardianship should be filed on behalf of a person, we intend to take that petition to the end, even if the patient discharges in the meantime. I think that is just good as human beings to do. I think it also helps with the credibility that the hospital has in the community for, that patient will maybe end up in a long-term care setting or something similar. And it would not, garner affection for the hospital if they were just, letting people go without following through with establishing a permanent surrogate decision maker for those individuals. So we definitely try to follow through. As far as filing in the first place, I know that can be difficult, and I know it's difficult in the outpatient setting to get those off the ground too. Your third question, I think it was regarding instances, when it's appropriate to listen to a surrogate or rely on surrogate decision making when a patient is kind of maybe questionable capacity. It sounds like you guys have a reasonable process, good instincts. I don't think that there's good black and white. Maybe John can kind of talk about that a little bit more. As far as the guardianship setting, it really depends on the procedure, depends on the urgency, depends on how fast somebody can get into court if there's a question. So I think that, that's hard to answer black and white as well. But if you have something to clarify that way, I'm happy to. Go ahead, Bianca.
I would add that we are always trying to be forward thinking. So if we're going to submit for guardianship, and this patient needs a PEG, they need antibiotics, they need something else, we try to get that all up front and together. So when we submit, we can get consent for all of those pieces when we first go to court. And so we definitely try to address that at the beginning. We don't want to be filing and then being like, oh, this patient needs this. Oh, this patient needs this. And so we will ask the team to please let us know everything we should be filing for. And I think the question, I think, kind of arose from something that I mentioned as well, is that, when we have patients that, and John can speak to this much better than I, when we have patients who, I think of a patient who was, had significant mental health issue concerns, and we weren't sure if they understood the complexity of what was happening with them, and we sought a guardian, but this person needed a surgical intervention, right? And do you take this person to the OR? Do they agree? If they don't agree, right? And when we have those, I think every case is different, and it depends on what intervention the patient needs, and it depends on what the patient is able to express, and it depends on also what the guardian is willing to step forward with as well. And then we all try to get together with ethics, with risk, with everybody, right, to discuss those cases, because it's not always straightforward as to how we proceed. But again, John and our attorneys can talk to how we look at all those cases, because they are different.
I'll agree. I think all of these are very fact dependent. Every case is different. There are occasionally times where we might consider questioning an existing advance directive if the person who is challenging it can provide us with, evidence or indicators that the patient had changed their mind since they had last expressed those wishes to somebody, or since they had last signed something. Those are rare, and I think that that's one of those situations where I would go running to Michelle and Amy. But typically, if the patient has expressed their wishes, it's in an advance directive, it's in a post form, something, we will honor that. And if someone challenges it, we will remind them that the patient has the right to determine what happens to their body. But if they do provide us with compelling evidence of that they changed their mind, we'll consider it. I hope that answered the question.
I know we're running a little bit over time, but there was a really great question about the differences between withdrawing and withholding. If we don't mind just answering that question really quick for anyone that is able to stay a little over 1 p.m. Of course, if you need to run to another meeting, feel free. Anyone would like to answer that question?
What question was that?
The difference between withholding and withdrawing care or treatment.
I can speak there are multiple comments in the chat about it. And so I think what people are struggling with is that there's, ostensibly no legal distinction between withdrawing and withholding life-sustaining treatment. However, at the same time, we have to hold this fact that clinicians are not obligated legally or ethically to provide interventions that are deemed non-beneficial or potentially even harmful. And so I think the questions are, how do we understand those differences? Can we for instance, withhold when there's agreement, it's non-beneficial medical interventions, potentially even harmful medical interventions without a guardian. Is that ever legally justifiable? Yeah, so if anybody could speak to.
And please, fellow panelists, correct me if I'm wrong, but there's you're right. Withholding, withdrawing there isn't much of a legal distinction, but there is a distinction if you're talking about withholding care that is not already existing and life sustaining. So, for example, we wouldn't withhold care that a patient is currently receiving or withdraw care that a patient is currently receiving, which is pretty much the same thing. We wouldn't do that without following the proper channels. However, we don't have to escalate care beyond what the patient is already receiving, even if it may be life-sustaining, if it is determined by the care team that providing those additional life-sustaining treatments are futile or won't have significant medical benefit. Did I say that right, Michelle, Amy?
I think that's a really great way to frame it, of if the patient is already receiving life-sustaining treatment, there's no distinction between withholding or withdrawing that treatment. That said, on the basis of medical futility, care doesn't need to be escalated, which is part of the rationale behind, physicians can, according to the DNR policy, sign a DNR order not to resuscitate a patient if that's deemed medically inappropriate to do so.
Unfortunately, we are over time. Thank you so much to our panelists and everyone for attendance. I know there are a ton of really great questions in the chat. I will be sending out these slides at the end of the day, and they will contain the speaker's contact information if you have any questions and want to send to them directly. Otherwise, there is a survey that will go out at the end of this, and information on how to obtain continuing education credits will be sent out as well. Thank you so much. Have a great day, everyone.
Thank you.